Hello, welcome everybody to this panel session on injunctions in patent cases. This morning with a panel, we will explore situations in which injunctions may be denied in patent cases, particularly pre-trial injunctions, preliminary injunctions. But before I introduce the panel to you, there are a few technical housekeeping issues that we should go over with you. First of all, if you're not familiar with Zoom, to the bottom of your screen, you see a number of icons, amongst which there is a Q&A icon. If you click on that, it will give you a pop-up window where you can enter questions to be asked to the panelists, either during or at the end of the panel session. What I propose is that if you have any questions, that you just put them in as we go along. I will either pick those questions up and ask them to the panelists at a moment which seems appropriate, or I will include them at the Q&A session that we will have at the end of the panel discussion. And if, of course, there are too many questions, we may have to stop somewhere, but don't be shy and just enter your questions whenever you have one. Should you have any technical difficulties, there's also a chat function. If you click on that, anything that you type in there is not meant for the panelists, but for the technical support to help you sort things out so that you can continue to follow the session and the discussion. And hopefully that will work for you. So any technical questions, please put them in the chat function, and any questions to be discussed by the panelists, please use the pop-up screen for the Q&A. So then I'm going to introduce the speakers to you. And hopefully you can now all see my screen. So we have a very interesting and esteemed international panel today that I'm going to introduce to you. You will see on screen the slide with their pictures, but you can hopefully also see in the Zoom function, you can see them live as they are speaking and as we have our panel discussion. But let me start by introducing them to you. First, from the United States, we have Claudia Frost, who is a senior partner at Orrick in the Houston office. She is a first-chair trial lawyer who has tried over 40 cases to verdict and has been lead counsel for hundreds more. She has been lead or co-lead co-counsel in over 50 patent infringement cases in courts throughout the United States, including the ITC and Federal Circuit. She holds a BA from the University of Texas, and a JD magna cum laude from the University of Houston Law Center. Claudia has been extensively recognized for her practice and her vast knowledge and experience in all aspects of patent litigation. She is a member of the American Board of Trial Advocates, has been recognized as one of the 20 most influential women in IP by Law 360, is a fellow in the American Academy of Appellate Lawyers, and has been widely recognized for her trial skills and appellate advocacy. She has also been named a Texas super lawyer for over a decade and is in the top 50 women lawyers in Texas and top 100 lawyers in Houston. She's held numerous management positions in the firm and in earlier firms where she's worked before joining Orrick in their Houston office. Then from India, we have Mamta from Inttl Advocare, where she works in their main office in Noida in the National Capital Region of Delhi. She's an attorney with close to 13 years of experience in handling various IP litigations, including patent litigation. Over the last few years, she has been expertly handling enforcement actions involving complex IP issues, securing injunctive relief and seizure of infringing goods in various jurisdictions. She has been closely associated with significant IP contentious matters in India. And besides handling key clients from various industries, including foods and beverages, liquor, garments, cosmetics, fashion accessories, computer software, pharmaceuticals, fast-moving consumer goods, etc., she also handles border measure complaints in the field of computer software piracy. She's a member of Inttl and of the Bar Council of Delhi and the Delhi High Court Bar Association. Then from France, we have Marianne Schaffner, who is a partner in the Paris office of Reed Smith. She heads the intellectual property team in Paris and the patent practice in Europe for Reed Smith. She's a well-known intellectual property litigation lawyer who is recognized for coordinating and managing complex national and transnational patent, trade secrets, and trademark disputes in the healthcare, chemistry, technology, and telecommunications sectors. She assists clients in negotiating intellectual property agreements, defining employees' inventions, compensation policies, and evaluating their IP portfolios to strengthen their position in mergers and acquisitions, financing transactions, and initial public offerings. Excuse me. She has studied and worked in the UK, Germany, the Netherlands, and the United States, and as such, she has an extensive knowledge both of the European and American judicial systems. She is a lecturer in the Master II of Intellectual Property Law of University Paris-Est, and also teaches at the École de Formation de Barreau de Paris, the Paris Bar School. Then finally, from the United Kingdom, we have Zoe Butler from the firm Powell Gilbert, who is an experienced IP litigator with a strong technical background and she has advised clients on IP disputes relating to a broad range of technological areas and industry sectors. And she is particularly known for her expertise in advising clients in complex patent disputes, often with an international element. She has recently acted for a range of clients from telecoms, electronics, software companies to pharmaceutical and biotech companies. Zoe also advises on related issues arising from international technology standards, such as patent pools, licensing, and FRAND, and counsels on patent litigation strategy, including pharmaceutical lifecycle management, with a wealth of experience in providing freedom to operate and due diligence advice. In addition to representing clients before the UK courts, including up to the Supreme Court, Zoe has experience of European Patent Office opposition proceedings and has represented clients in arbitration proceedings and mediations relating to technology contract disputes. She has been involved in many multi-jurisdictional disputes, working with advisors from across Europe, North America, China, Korea, Japan, and Australia, and in many instances has taken a role in coordinating such litigation. Zoe has also been appointed by the UK courts to supervise the execution of search and seizure orders by other firms. And she frequently lectures on IP law and is a tutor on the Oxford University Diploma in Intellectual Property Law and Practice. And she's also a contributor to the SIPA Guide to the Patents Act. Additionally, Zoe has also lectured on the Bristol University Law School Distinguished Alumni Lecture Series. Then finally, myself. My name is Koen Bijvank. I will be moderating the panel discussion today. I am a partner at Brinkhof in Amsterdam, which is a boutique litigation firm, and my specialization is in international patent litigation, both before the courts in the Netherlands and before the European Patent Office. And my practice is mainly in the area of chemistry, pharmaceuticals, and life sciences. So then moving on after that introduction to our panel discussion of today. So as I said at the outset, we will mainly focus on pre-trial injunctions, but occasionally we will try to contrast those with permanent injunctions, or if you perhaps will, trial injunctions. Before we go into all of that, I think it's important that we recognize that when it comes to pre-trial injunctions, the way the courts deal with those is very much a matter of a procedural tradition in countries, and much less a question of the substance. And that is also where we want to focus the discussion today. So what we will not be talking about is infringement and the validity of the patent, but much rather on the other factors that determine whether or not the court will grant a pre-trial injunction. And amongst our panelists coming from different legal traditions and jurisdictions, I'd first like to ask for their views on what I think is probably a fundamental difference, and that is between common law systems and civil law systems. And probably, even though I said we will not deal with the substantive matters like infringement or validity, I would first like to clarify in all the different jurisdictions to what extent the courts will at all look at the questions of infringement and validity when considering the question of whether or not a pre-trial injunction should be imposed. So perhaps as a representative from a civil law system, probably the only one amongst our panel, I'd like to ask Marianne for her views on that, and perhaps a little bit of explanation of how the French courts deal with this.
Thank you, Koen. So to start about the differences between common law and civil law systems, actually, I think what matters really is the question of balance of interest, which is much more something that we can see in the common law, which we do see less frequently in the civil law systems and in France, I would say. What is interesting, I would say, with respect to balance of interest and the proportionality, actually, is that in France, in the past, when we were trying to get preliminary injunctions, actually, we had to prove that the injunctions measures were proportionate. This requirement has disappeared when French law has been amended in '84, and where we actually requested that only we prove that the action on the merits will be likely be successful. So, and then the requirement of proportionality has disappeared. So now we have implemented the directive without the requirement of the proportionality. However, it is true that when we read the directive, the European Enforcement Directive, actually Article 3 says that the measures and remedies shall be effective, proportionate. And when we look at the recital, that's the 2022 recital, we say that the courts must ensure the proportionality of the provisional measures. So we see that even though actually this is not something that we often see in civil law systems, via actually the EU law, we have again introduced the proportionality and actually the balance of interest. And then just to focus on the second bullet point of your presentation, what is the role of the merits? That is to say, infringement and validity. That is true that this is something that is really taken into consideration by the courts before making a decision on whether there is a likelihood of success of the action. That is to say that infringement is there, and that obviously the validity of the patent appears to be very strong. The patent is presumed to be valid, that is true, but really if there is a high risk of revocation on the merits, then the injunctions are not going to be granted. Do you want to hear about the differences about the preliminary and permanent injunctions now or later?
And let's leave it at that, and let's move to some of the other panelists and see what they have to say about this. But if I understand from you correctly, Marianne, then certainly the courts in the context of a pretrial injunction will look at infringement and validity, but the test is somewhat different compared to in a full merits case in the trial. And there will be if there's a likelihood of infringement, that is sufficient for granting a preliminary injunction generally. Okay, thank you very much. Then perhaps the country where the common law tradition started for all of us, let's move to the United Kingdom. Zoe, can you contrast the situation in the UK to what Marianne just explained to us about France?
Sure, of course, Koen. Yeah, so perhaps focusing, I think, particularly on the role of the merits, because certainly my experience of seeing preliminary injunction proceedings play out in the different courts in Europe, the emphasis placed on an analysis of the merits in PI proceedings does seem to be something that a particularly sort of stark difference. So in the UK. The first question that the court will ask itself on a preliminary injunction application is whether there is a serious issue, a serious question to be tried, so that is a sort of a threshold question. But the reality is it's a fairly low threshold, and what's clear is that the courts, and it's well settled in our case law, is that the court shouldn't attempt a kind of a mini trial of the substantive issues, but should simply confine itself to asking whether there's a serious issue. And in reality, what this tends to mean is that there's very little time spent at preliminary injunction hearings debating the strengths and weaknesses of the case on infringement and validity. I mean, it can play a role, but it doesn't tend to be where the focus of the arguments lie. And a sort of perhaps just to give a sense of this, a recent example, a decision that was handed down by the Court of Appeal, actually earlier this year during lockdown, where a patent had been held invalid by the opposition division at the EPO, but that decision was suspended because there was appeal pending to the Technical Board of Appeal. And there, the Court of Appeal accepted that there was still a serious issue to be tried. Now, the PI failed, but that was on other grounds to do with adequacy of damages. But on that threshold question, the fact that that the opposition division had found the patent invalid wasn't in itself decisive. And equally, we've had decisions where patents have been held invalid or not infringed at first instance, but nonetheless, a PI has been granted pending appeal, because to be able to appeal, you have to show there's a serious issue to be tried, and effectively that answers the first question that the court has to address on a preliminary injunction application. So I think that is quite a difference in my experience.
Thank you, Zoe. That really does sound like a difference. Just speaking for another civil law jurisdiction myself in the Netherlands, the example that you just gave where an opposition division of the EPO has just revoked a patent, even though an appeal is still pending in the Dutch courts, even though it's theoretically possible that you can convince a PI judge that that decision of the opposition division is wrong and that the PI should be granted, in reality that the chances for that happening are very, very small indeed. Because they will seriously look at the validity of the patent as well.
I mean, where it could sometimes come in, although it doesn't typically, is where the harm that would be suffered by both, there's irreparable harm to the patentee if a PI is not granted, and equally there would be irreparable harm to the defendant if it was, and that's very finely balanced. Then in theory, it's something. The sort of the relative strength of the party's case is something the court could take into account, but typically that isn't part of the analysis. Typically you get onto balance of convenience type arguments, which I know we'll come on to discuss. Yeah.
Okay, I just to ask you, I got a question from a participant for the name of the case that you just referenced. Can you help us with that?
Of course. So the case it's Nurim versus Milan. And it was a decision of the Court of Appeal this year, so 2020. I think it was May or June, but Nurim, N-E-U-R-I-M versus Milan.
All right, thank you very much. Then moving on to, I guess, warmer pastures. Mamta, if you look at this question from an Indian point of view, would you say that the Indian tradition is firmly in the square of the common law system, and is the Indian approach as to the role of the substantive issues closer to what Marianne described for France, or closer to what Zoe outlined for the UK, or is it yet completely different?
I would say, thank you, Koen. I would say it's closer to Zoe because yes, we follow the three-pronged milestones, which is prima facie case, balance of convenience, and irreparable injury. When I say prima facie case, that means a patentee who has gone to court to enforce its patent has to establish whether its patent is valid prima facie, and there is a prima facie infringement. But at the same time, the defendant who is alleged to be infringing the patent has a defense in law that the patent is credibly invalid, and it has a potential challenge to it, what Joe had just said. So at a prima facie stage, if the defendant is able to show to the court that there is a credible challenge to the validity of a patent, then the court will probably not go into the next limb, which is balance of convenience or irreparable injury. Or in other words, if the patentee is able to establish that it has a strong patent and there is a clear-cut infringement, and then alone the court will move into balance of convenience or irreparable injury. So we follow very much closer, to answer your question, we follow closer to what Joe had just said. And yes, it is an equitable relief in India. PI is a matter of discretion of the court. And that's how I would say we are a little away from Marianne and closer to Joe.
Thank you, Mamta. Then we're moving to the United States, which I would certainly firmly put in the common law area. But I think there are quite some procedural differences in the United States legal system. So, Claudia, can you please comment on this question? What is the role of the substantive questions of infringement and validity for US courts in their assessment of whether or not to grant a pretrial injunction?
Certainly, and thank you, Koen, very much. The United States considers 4 factors in determining whether to grant a preliminary injunction. And not surprisingly, the first one is likelihood of success on the merits. And of course, in the context of a patent infringement case, that includes infringement and validity. In fact, we did a sort of unscientific survey here in preparation for my remarks today and looked at all of the cases in the United States over the last 12 months where a preliminary injunction was sought. And in those cases, there were only 28 of them. So preliminary injunctions in patent infringement cases over here are not common at all. But even in those cases, only 2 of the 28 we found were granted. So about a 7% success rate. So I looked carefully at those 2 and compared those to the rest of the cases where a preliminary injunction was sought. And I think you can take away from those cases and the conclusions that absent a showing of likelihood of success on the merits, a patentee will not get a preliminary injunction in the United States. The way that the detail and level to which the courts delve into the issues varies a bit from court to court and from case to case, as you would expect, because it is each proceeding is different and it's decided on its own facts. But as a general rule, what courts do is they will look at infringement using the same lens that they would use in a trial on the merits. You would look first at claim construction, and then you would make determinations with regard to claim construction as were necessary in order to make the evaluation. And then you would make a comparison of the properly construed claims to the accused products. As other panelists have mentioned, this is not a trial on the merits, so there's not as much scrutiny, there's not as much requirement. It's to show a likelihood or substantial likelihood of success, not an absolute success on the merits. But that's what the courts do with regard to infringement. They look at claim construction and then they look at the properly construed claims and compare those to the terms and compare those to the claims of the patent. As for validity, it's a bit different in the sense that in the United States, because of the presumption of validity, for a defendant to establish that a patent is invalid, you must show that by clear and convincing evidence. It's a very, very high threshold. It's as close as you can get to a criminal law threshold in civil litigation here. But in the PI context, clear and convincing evidence and showing invalidity is not required. What you have to show essentially is vulnerability, and that's really more the issue. So is the patent vulnerable to being invalidated on the merits? And if a defendant can show that a patent is indeed vulnerable to being invalidated, that goes a tremendously long way in defeating a preliminary injunction. By contrast, if the defendant fails to raise a substantial question of the patent's validity and it appears that there's a substantial likelihood of infringement under a proper claim construction, then a preliminary injunction will be considered. It's not the only factor. Our second factor of irreparable harm, which we'll talk about more later, is probably maybe just as important, but I would say from a gating standpoint, the merits first and substantial likelihood of success, and then irreparable harm are the 2 most important factors in the U.S.
All right, thank you. And I think that, at least for me, that raises a number of questions, because in a common law system, certainly in the UK, but I think it's the same in the US, for a permanent injunction, the court makes that assessment after trial. And a lot of the evidence is being adduced at trial in the form of, a cross-examination of experts, witnesses. So a lot of the evidence may not be available to the court when they have to make the assessment on a preliminary or pretrial injunction. That, of course, is different in civil law systems where much more of a front-loaded system is in place, and the written submissions will contain much more of the argument about that. So if we move to the difference in standards, both standards, but I guess also procedurally in how the courts address questions of preliminary injunctions, how would that then play out in the United States, Claudia?
Well, obviously, in the permanent injunction situation, you've already, if you're the patentee, you've already won. And so the merits have been resolved in your favor. You have a valid patent and it's been infringed by the defendant. And so that issue is already in place. The focus then really becomes irreparable injury, and you begin to get into more of the balance of the equities in the public interest at that point. And those become much more important. In the US, unlike in some places, you don't automatically get an injunction anymore after the eBay decision, which many of you are familiar with, I'm sure, out of the US Supreme Court. It's not an automatic patent injunction upon a finding of infringement. So it's the court engages in a very extensive, often evidentiary hearing to determine the propriety and need for an injunction, or whether there's an adequate remedy in damages in a running royalty going forward or the like. In terms of the evidentiary point, though, Koen, it's really interesting, I think, and I was somewhat surprised, to tell you the truth, reading a number of these cases as I did to prepare for today, how much evidentiary support was actually brought to bear in the preliminary injunction setting when the preliminary injunction was actually granted. In those cases in the US where a preliminary injunction was granted, the few, the quantum of evidence and the type of evidence and the sophistication of the evidence was quite rich and quite plentiful. And so I think that speaks volumes to why perhaps the patentees in those two cases where PI was granted in the United States, why they succeeded, because they had very good evidence and very good expert declarations and other support for their position.
So that sounds to me like perhaps in the United States, even though it's a common law country, there is perhaps less of a distinction between the situation for a permanent injunction and for a pretrial injunction, in the sense that there's already a lot of evidence necessary at the preliminary injunction phase, and perhaps aside the question of validity, certainly for infringement, the court will make a fairly detailed assessment of the merits of the case, whereas also at the end, before a permanent injunction is granted, it sounds to me like a lot of the factors that the court takes into account before granting the permanent injunction, they sound very much like a balance of convenience type of, irreparable harm and adequacy, equity kind of considerations that in most civil law countries only play a role at the preliminary injunction stage. Would you say that's correct?
I think so, yes. And I think the irreparable harm factor is going to be dominant at that stage. More than the others at the permanent stage. If damages are adequate to compensate and that's an adequate remedy, then the need for an injunction becomes, of course, lessened substantially. And I think though, Koen, that the people who are successful in their preliminary injunction come loaded with a lot of evidence. I'm not sure that the people who weren't quite as successful came with that, bringing that to bear. And in particular, that becomes important on the irreparable harm issue, I think, in the United States, which we'll talk about. But I think people fall down more at the preliminary injunction stage, perhaps on that prong than they do on the others. So
that sounds like it's difficult to say what the level of evidence is that's really needed at the pretrial injunction stage. And the ones that were successful perhaps did too much. But they erred on the safe side, and there are no cases, if I understand correctly, where the injunction was denied for a lack of evidence on the substantive matters.
I think that you could say there wasn't enough evidence. If you didn't show a substantial likelihood of prevailing on the merits because your evidence was not sufficient, then there was a failure on your evidence. It's not so much on the quantum of it, but maybe on the quality of it.
Sure.
You might not have been as persuasive or have enough in your presentation to be able to convince a court that you would in fact succeed, or the defendant might have been very persuasive in showing that there was a substantial question of the patent was vulnerable and there was a substantial question of validity there. But I do think that seemingly in the cases that were successful, there is there was a very strong showing made with a lot of evidence. There were claim constructions. There was a lot of effort and a lot of evidentiary support for those grants.
Zoe, do you see something similar in the UK where the courts also make an assessment of these equitable factors before they grant a permanent injunction after the full trial has been conducted? And can you also comment on the level of evidence needed for a preliminary injunction? Because you mentioned that you have to show that there is a serious case to be tried. But you also said that threshold is very low. But does that require a lot of evidence to show that in fact there is infringement and the patent is valid?
Sure. So I think this is where, although in the UK, like in the US, a permanent injunction is an equitable remedy, so it's within the discretion of the court. I think there is quite a difference, I think, between the approach of the English courts and my understanding, particularly from what Claudia said in the US. So for a permanent injunction in the UK, so obviously there's been a full trial and a finding of validity, valid infringement of a valid patent. The starting point for the court is that an injunction is the normal remedy. And so the burden is very much on the defendant to give reasons why an injunction shouldn't be granted. And the court can take into account all the circumstances, including issues of public interest, including for third parties. But the reality is that it's difficult for a defendant to defeat that permanent injunction, at least in the sense of knocking it out altogether. So there've been a couple of recent cases in the life sciences sector, the Evalve and Edwards case, and Kymab and Regeneron, where there have been questions about carve-outs for permanent injunctions in particular circumstances. But the court is starting from the perspective that an injunction, a successful patentee should have an injunction unless they're really persuaded otherwise. For a preliminary injunction, the court in the UK is asking itself a very sort of rather different question. There's certainly no presumption, to put it in those terms, in favour of a preliminary injunction. And what the court is really asking itself is how is it best able to put the court at trial in the position where it can do justice. And obviously at that stage it doesn't know what the outcome of that trial will do. So it's really assessing whether the granting or withholding of a PI is more likely to produce a just result. And in doing that, it asks itself, I think Mamta referred to it as the American cyanamide questions, sort of four stages to this approach. The first one is there a serious question to be tried? And then the court goes on to ask, firstly, will damages be an adequate remedy for the patentee? And I think, as Claudia said, certainly in the UK, and I think there have been a few recent examples where patentees have failed on that question. They failed to show that they would suffer irreparable or unquantifiable damage. So that is a really important question, certainly in the UK. If the answer to that is no, damages wouldn't be an adequate remedy for the patentee, then the court asks, well, would damages be an adequate remedy for the defendant if I grant the PI and there's a finding the defendant is successful at trial, would damages be adequate? And if those two irreparable, if there's irreparable harm on both sides and it's evenly balanced, then the court will go on and ask itself the questions of balance of convenience. So, you know, status quo, those questions, which I know we'll come on to discuss. In terms of evidence, so it's all written, it will be based on written evidence. So it's, in that sense, there's quite a contrast to a full trial in the UK where we have, you know, live testimony and cross-examination. It will be on the written evidence, and a lot of evidence is put in, but it tends to be more on the questions of irreparable harm and balance of convenience. So you know, there might well be evidence on the merits of the case, but as I say, because it doesn't tend to be such a focus. It's often conceded by a defendant that there is a serious question to be tried. They might put in evidence nonetheless to sort of try and sort of prejudicial, really, to try and show, give the judge a sense of the weakness of the patentee's case. But more of the evidence tends to be focused on the questions of irreparable harm and balance of convenience. And this, you know, it can be difficult for the judges to deal with this on the paper, in the sense of they're used to live testimony and the ability to cross-examine. But you know, they can read the evidence and weigh it up. There was a preliminary injunction case, I think it was last year, in the eValve and Edwards dispute, where the question of public interest was raised as a reason why a PI shouldn't be granted. Now, in the end, the judge didn't need to get to that question because the patentee failed on irreparable harm. But I think the judge did observe that there was a huge volume of evidence and a lot of time and money had been spent on this public interest aspect. And the judge sort of questioned whether these were really the sorts of proceedings where the court could properly evaluate that issue. But you know, if that's something you need to rely on, then you need to put in the evidence to substantiate it.
Thank you, Zoe. Mamta, do you see the same distinction in India between the discretion for the court to grant a permanent injunction and the discretion in a PI situation? Can you compare the Indian approach to what you heard from Claudia and Zoe?
Yeah, so thank you, Koen. So in India, I would say it's a hybrid, what Claudia had said and Joe had said, in a way that in a PI stage, the threshold is to establish that you have a prima facie case for a patentee, and for a defendant, it's a threshold that there is a credible challenge to the validity. The merit of the case becomes very, very pivotal, and both the parties therefore submit their best evidence at the time of contested PI and file all the documents and file all the expert evidence, and there is a substantial hearing to determine in a contested PI whether the PI has to be granted or not granted. Whereas if you go at a trial stage where the permanent injunction has to be granted, then the law of evidence stepped in, which is like all your documents are testified on the touchstone of evidence, whether it is it has an evidentiary value, whether what you have said in your pleading, and whether the expert who have deposed something, whether the other side will get the opportunity of cross-examining the witness and bringing out the facts relevant to their case. So in our experience, it all depends that, you know, like how best evidence you have produced is one aspect of the matter at a PI stage, but how best the trial has been conducted at a permanent injunction stage. These are two very, very different skill, different level of involvement. But so far as court is concerned, the objective remains the same, whether the patentee has a right or whether the defendant has been able to establish, it's no longer a credible challenge to the validity of the patent. The defendant has established that it is an invalid patent, or the defendant has established that there is no infringement. So the stage has its different role, a different level of evidence, and a different level of inquiry from the court as well. So I would say, coming back to Claudia's comment and Joe, it's very much a kind of a hybrid system, if what I have understood from their discussion.
Interesting. So the contrast between common law and civil law countries is perhaps not as great as you would think. But let's move to Marianne and test that hypothesis. Is there any discretion on the part of the French courts at the trial stage, once it has been established that the patent is valid and infringed? Is there still any room for the court to deny a permanent injunction?
Actually, when we are at the permanent injunction level, actually, when the court has decided that there is infringement, then the injunction is going to be granted in the end. That's part of the consequence, actually, of the infringement. Where the court may have some discretion, actually, is with respect to the recall of the product from the network. The court might have some discretion to order that kind of recall. However, the real injunction, I would say, as we understand, actually, there is no discretion at all, because that's really the consequence. So, which means that what we've heard in the US, I would say, the proof of infringement, then you get the injunction. Which is different from the preliminary stage, where you have to prove reasonable evidence of infringement, and for some reasons it can be refused, not only because of the invalidity or risk of, or infringement, but also maybe because it would not be proportionate, because there is no irreparable harm. This is something that now we can see in the decisions. And what is interesting as well is often the court will take into consideration when the patent or the SPC in the life sciences space is about to expire. And very recently, actually, there were some decisions made by the French courts which say, okay, that the SPC was just about to expire, so there was no risk to grant the injunction, because actually the patentee could be repaired by in money in the end. So this is something that we have seen often. So this is taken into consideration. Or to grant an injunction, we have seen in the decision in favor of Merck that it was suing actually a generic company, and in the end, the injunction was granted, even though the patent was about to expire. But because the court said, okay, actually, the generic company would benefit from an undue competitive advantage towards the other generic companies, because it would be on the market. So what is interesting in that decision is that it took into consideration not only actually the interest of the patentee, but the interest of the entire market, the competitors of the infringer, which would have actually suffered from the possibility for the generic company to continue the infringing acts, even though the patent was about to expire. So this decision actually was made last year in 2019. But to respond to your question on permanent, there is no discretion at all, really, when we speak about injunction.
So there is no room whatsoever for a defendant to raise any public interest defense at all for a permanent injunction?
You actually, yeah, of course, then you try it, and we've seen that in some cases, but actually in the end, it does not prevail, or it has not prevailed yet. Actually, it's not that it will never prevail. Maybe it's because it has not been proven enough. But actually, at the moment, there is no injunction which has been refused on the basis of in public interest on the merits level, I would say.
Interesting, thank you. And that raises to me the question, at least for European jurisdictions, what the role is for the IP enforcement directive. And we will get to that also in the area of ex parte injunctions. But before moving there, before I forget, there was one question from the audience for Claudia. If you can name the two cases where a preliminary injunction was granted. Do you have them at your fingertips?
I do. I do. One is from the Northern District of California. It is styled Illumina, ILLUMINA, Inc. versus BGI Genomics. And the second one is from the Southern District of New York, Spin Master Limited versus initial E, Mishan, MISHAN, and Sons. And that's a 2019 case. The first one is 2020.
Thank you.
I have the citations if you need them, but that should get somebody to them.
Okay, well, no doubt there's a way for people who have further questions to get them to us by email, and we can provide that information to you.
Certainly. Happy to do it.
But then, as I announced, moving to considerations based, at least in Europe, on the IP Enforcement Directive. In Europe, in Germany, for a long time, there has been a possibility for parties to get ex parte injunctions where you can approach the court without the defendant being heard. And sometimes the court grants injunctions, and that possibility has been included in the IP Enforcement Directive. So for the Netherlands, for instance, we have that in our law now, and it has been used in a few instances, for instance, where the manufacturer has been injuncted in a full merits case, and then there is a wholesaler who continues to deal in the infringing product, and then clearly, they were not a party to the merits case. So technically speaking, they haven't been heard, but the same arguments would apply, and the courts sometimes have granted ex parte injunctions. But at least in the Netherlands, it's very unusual and very rare. I was just wondering if other jurisdictions have such an opportunity or possibility, like in Germany. Certainly, by definition, the UK and France must have it. But I was just wondering if there are any examples of people having tried it or been successful. Zoe, can you perhaps start, because we're a bit in a hurry. In a few months' time, the enforcement directive no longer applies to the UK, unfortunately.
Let's not spend time on that. So ex parte injunctions without notice injunctions are, you can apply ex parte. Tends to be obviously in cases of urgency, and the court requires reasons to be given as to why you've come to the court without notice of the defendant. I think tied with our tradition of discovery or disclosure in the UK, as in the US, there is an onus on the patentee to give what we call full and frank disclosure. So you have an obligation as the party asking for the ex parte PI to bring to the court's attention matters of which you are aware the other side would bring to the court's attention if they were present. So anything that's detrimental to your application, you should bring to the court's attention. What typically happens, and there are instances where ex parte injunctions have been granted. What typically then happens is you can get it within a matter of days or even hours. I had an example case 10 plus years ago where we were aware that a party was literally about to launch, in a matter of a day or two, and we got down to the court that afternoon on learning of it and got an ex parte injunction. But we had to put the other side on notice and return to the court in a very, very short time frame, a matter of 2 or 3 days. And then we were into effectively an inter partes preliminary injunction procedure. So it does happen. It's not that common, I would say, in patents, but there are examples.
It sounds like a similar standard then to the one that the courts in the Netherlands apply, and that is you have to convince them that there is no time, and of course that depends on the schedule of the court, but there is no time to conduct a normal inter partes PI hearing and at least hear the defendant before the court comes to a decision.
Yeah.
Marianne, is that similar in France? Have there been any examples under the IP Enforcement Directive, or perhaps ex parte injunctions already existed in France prior to the IP Enforcement Directive?
So ex parte injunction did not exist prior to the IP Enforcement Directive in France. So the threshold, I would say, is quite similar to use in the Netherlands. That is to say that, first of all, you have to prove urgency, that is for sure. And that really the circumstances imposes that the other side is not heard. What is interesting, that there was one case roughly 10 years ago where a party tried to obtain an injunction on an expiry basis just on the wrong ground that the other side was Chinese. And that because just before the injunction was applied for, actually, they tried to, or they performed what we call the saisie contrefaçon, to collect evidence of the infringement. And actually that was during a fair trade. And the alleged infringer actually tried to hide some pieces of evidence, to take some of the devices that were exhibited and so on. And that was also the reason for the patentee to try to get an ex parte injunction. And in that case, actually, the court say, okay, the fact that the company is Chinese is not sufficient to actually to grant an injunction on ex parte basis. And then second, the fact that they try to hide some pieces of evidence of the infringement is not either a good reason. So we have obtained some ex parte injunction, but they are very few. And actually, I would say that for the moment, the injunctions which have been granted on ex parte basis are in the life sciences space and against generic companies in the end.
Thank you, Marianne. Are ex parte injunctions available in India, Mamta?
Yes, Koen, very much. So this is one of the most important tool, and I would explain why. The parameters remain the same, that you have to satisfy the court that there is an urgency, and other parameters could be that the infringing product, which is manufactured and is stocked in the premises or in the warehouse or factory of a defendant, maybe get flooded in the market without proper accounting. Or you want to have the stock, how much is the stock of the infringing product, that has to be accounted for, and an inventory has to be prepared. And also that it is very urgent, you have come to know immediately, you have approached the court, and therefore the infringing product should not be allowed to be in the market. This situation can also be in a qua timid action where the apprehended launch is yet to take place, and therefore there is an urgency that immediate injunction order may be passed so as to prevent that threatened launch, and the court may hear the arguments of the patentee or the generics or the two parties, and then having been satisfied, the case put forth by either party, whether the injunction, whether the defendant should be allowed to put the product in the market or not. So to answer your question, Koen, ex parte injunction is very much available in India, and it's very much preferred by the patentee to have its interest protected, and the courts do grant, provided you make out the case that there is an urgency, you have approached the court immediately, and there are other factors which necessitates courts to pass such orders.
Am I right to assume that, like we heard from Zoe and Marianne, there is an obligation on the patentee to be complete in informing the court when you're the patentee, when you approach the court for an ex parte injunction? Is there any example perhaps where afterwards it was shown that the patentee was a bit under diligent in providing all the information to the court? Is there some sort of a remedy or a punishment in that sense?
Actually, if you have not been loyal actually towards the court, then there is a possibility that the decision be quashed, because you have to tell the truth and to tell everything you know, and any circumstances which may have an impact actually on the decision made by the court to grant or not an injunction. So if you have been disloyal, actually unfair, then the injunction is going to be lifted.
Is that the same in India, Mamta?
I agree. So even if you have obtained the ex parte injunction, the other party can come to court and complain of that the full facts were not made before court, or a misrepresentation has been made. Or even there is a provision that you can file immediately, being a defendant, if I believe that ex parte injunction ought not to have been granted, then I can file an application for vacation of injunction and giving my grounds and making out the case and satisfying the court that why the injunction which has been granted without notice should be vacated. So there is a provision, and that there is a requirement in law that the court should hear such petition within 30 days. So there is a timeline. So it is kind of a balancing act that you have the provision of ex parte injunction, but at the same time, there is a provision that if you feel having injured because of such ex parte order, you can approach the court and ask the court to take up the issue within 30 days.
Thank you. Claudia, in the United States, are there any ex parte injunctions? Do you know of any examples? Is it even possible?
Well, under our civil rules of procedure, which govern the notice requirements for preliminary injunctions and what we call temporary restraining orders, which are ex parte injunctions. Let me talk about both of those really quickly. For a preliminary injunction under our rules, and this is Rule 65 of the Federal Rules of Civil Procedure for anyone interested, a preliminary injunction cannot issue absent notice and an opportunity for the adverse party to be heard. The temporary restraining order is the analog to the ex parte injunction we've been talking about here. And there, the court may issue a temporary restraining order without notice or oral notice to the adverse party only if two requirements are met. First, there must be specific facts in an affidavit or verified complaint clearly showing immediate and irreparable injury, loss, and that loss or damage will result to the movement before the adverse party can be heard in opposition, and that the movement's attorney certifies in writing as to all the efforts he or she has made to give notice to the opposing party and explain, if no notice has been given, why it shouldn't be required. It's a pretty uncommon practice in traditional patent litigation, in my experience. In fact, I think I've only been involved in one case where a TRO was actually sought in a patent case between legitimate business entities. Often TROs are entered in cases of counterfeiting and things of that nature, where you have to immediately stop people who are engaged in illegitimate conduct, or arguably illegitimate conduct. But in typical patent cases, it's not. Ex parte TROs are not common. Even if you get one, they don't last very long. Kind of like Mamta was saying, ours in the US only lasts 14 days. Often you have to post a bond in order to get one, and you can only renew it one time after the 14 days. So it can have a maximum extension of 28 days. And one of the conditions is that the preliminary injunction hearing be set very quickly. If a temporary restraining order is entered, then the preliminary injunction follows right behind it very closely, and as soon as it can get on the court's calendar. So it's an uncommon practice, but not something I could say is ruled out by our practice here.
So then the practice probably is for the patentee to try to even though they're very short in time, these temporary restraining orders, to let that be followed by a pretrial injunction, so that there is no lapse somewhere where the defendant can continue the infringement in the intermediate time, or is that something that's impossible?
Well, I think typically the court will set the hearing as quickly as possible on the heels of that. So sometimes it will be, within a week or 2 weeks. So it's a very accelerated schedule. Yes, there is a possibility, I suppose, of a gap in there or a lapse, but it's incumbent upon the plaintiff, the patentee, to move to get the court to set the hearing promptly. And in fact, the rules actually require that expediting the preliminary injunction is part of the consideration essentially given for the temporary restraining order. The court has an obligation at that point to set the preliminary injunction. If the court grants an ex parte TRO, the court must set the preliminary injunction hearing at the earliest possible time, and having that matter take precedence over all other matters on the court's docket other than those that are of similar nature. So the rules command the court to be expeditious in this, and the parties as well. So it starts a very fast moving train once you move for a TRO.
Right. Thank you, Claudia. Also, for the interest of time, I had a question here about the impact of whatever happens in the context of a pretrial injunction. How that would affect the outcome of the merits case. I'm going to skip that one for now because the topics that we have been discussing now seem to sort of naturally flow into the next one on my list, which is what other requirements there are and what perhaps topics or factors the court has to play with in setting a pretrial injunction. And some of them have been mentioned by all of you before. But I think it's interesting to explore if there are any clear-cut differences and how predictable it is, or to what extent really these factors all depend on all the circumstances of the case. For instance, the urgency requirement, and I think for all of us, it is a situation where there's a motion, if you will, where the highest urgency requirement applies to an ex parte injunction or a temporary restraining order. And then there is still a high urgency requirement for a pretrial injunction, and far less so for, of course, a permanent injunction, because there is no further down the line. So urgency probably doesn't play a role there. But sometimes clients ask us, is it still urgent enough? I heard about the infringement 3 months ago, 6 months ago. Is that so easy to answer that question? In some jurisdictions, perhaps more than others. So let's start with India this time, Mamta. Is there a clear-cut answer for a question like that?
The answer is sooner the better. So if you're able to explain, suppose you were conducting an investigation which took time from the date of knowledge. So long you are able to explain that there has been no lapse on your part to come to court, there has been no deliberate delay, then the urgency is maintained. But suppose it's not 10 days, the sooner you go, the better it is. That's the answer. But suppose I had to conduct investigation, find out more details about the defendant's activities and so on and so forth, and the report was made available to me from the date of knowledge after 2 months. And within 1 week, I go to court. Still, it is 2 months, 1 week, but it's urgent and it's immediate. So therefore, I would say there is no strict timeline. The only test which you have to meet is that you have maintained the urgency by taking the action, and without taking such action or requirements, you could not have approached the court. And if you are justified in doing that, it will fall into the category of an urgent situation.
Thank you. What sometimes happens is that parties are in negotiation to see if a license is necessary, if they can settle. How does that play a role in that context, Mamta? Because you've known about the infringement perhaps for more than a year, but you were in good faith negotiating. But at some point, it turns out that the negotiations aren't going anywhere, or perhaps the patentee would like to get some more leverage in the negotiations by filing for a PI case. How do the courts look at that situation?
So if the court is aware of that the parties were trying to negotiate and enter into some agreement or licensing regime, the court's approach would be that, okay, sit one more time or go for mediation. Definitely PI will be not the immediate approach of the court to grant you. So the notice would be issued, or maybe the parties are still pushed to try it out, and then matters are probably heard in court. So the court's effort would be that why don't you try through mediation? So I must clarify here, we have a mediation center which is in the court's premises, where the courts have the power to send two parties to a mediator who is a senior person, where the parties, not the lawyers, parties will sit together and try and redo the matter, and the courts are directed to make such endeavor so that the matters are resolved. So I would say that in such scenario, the natural course of the court and the natural reaction of the court would be to try one more time before any orders are passed.
How about the UK, Zoe? Is there a clear-cut urgency requirement? No doubt there is an urgency requirement, but how would you answer a client with the questions that I just asked Mamta?
Yeah, I mean, it's. I think as Mamta said, it's you should move as quickly, as you can. So delay, unexplainable, inexcusable delay, is likely to be fatal. But there's no hard and fast rule. There's no, within a month of learning of the infringement or anything like that. The court's going to look at it in the round, and I think where it often typically would play in is where if the court gets on to look at balance of convenience, then delay may well have caused, if there's been delay and a PI is granted, then there could be prejudice to a defendant. If a defendant has moved its business on, it's got customers, and then you're taking it off the market, the court's got to be satisfied that in balancing up the interests of the parties, that's something that that would be the just thing to do. And if they feel that the claimant has delayed and there's no proper reason for that or excuse, then that's going to very much count against the patentee. So that, yeah, no hard and fast easy answer, but I think, as Mamta said, you should move as quickly as you can to maintain the balance of convenience in your favour as a patentee.
But that sounds to me like in the UK, but probably also in India, urgency is not a separate requirement for granting a pretrial injunction, but it sort of falls into the more broader assessment of the balance of convenience. Is that a fair assessment?
Yes,
Yeah.
I would say yes.
How about civil law countries, Marianne? Would you say the same? Does urgency fall into a broader assessment of the interests of the parties, or is it something separate?
This is something which is separate, I would say. When we speak only about inter partes injunctions proceedings, actually urgency is really not a requirement, okay, while it is one when you try to get an injunction on an ex parte basis. So really, obviously you should not wait too long, and that's why I was saying that there are some decisions where actually the injunction was requested a few days before the expiration of a patent. In that case, it's going to be very difficult for you to obtain a preliminary injunction, obviously. However, as such, it's not at all a requirement to prove urgency, to have acted swiftly, provided that actually you are within the prescription. In the end, you are entitled to get an injunction. And if you bring a reasonable evidence of why, you should be entitled to the injunction.
How about the United States? Is urgency something separate, or does it fall into a broader assessment of the balance of convenience and the balancing of the interests of the parties?
Actually, Koen, I think in the US, we talk about the balance of equities and the balance of hardships and the public interest as the two of the four factors. But where I actually see undue delay becoming coupled specifically with a factor is on the irreparable injury prong. That's where it gets the most discussion in the US, at least in the cases that I looked at for this presentation. The courts look at whether you are able to show irreparable injury, and the fact that you have unduly delayed in bringing your action has some bearing on the irreparability of the harm. If it was that harmful, why didn't you move quicker? And in fact, that same analysis can, in some courts, have an impact on whether you're entitled to a permanent injunction after a successful trial on the merits. Often courts will say, well, you never moved for a preliminary injunction. You didn't do anything to try to stop the infringer from doing what you've now shown they were doing. You've unduly delayed in your attempt to get an injunction and to stop the defendant from engaging in the infringing behavior. So you shouldn't be entitled to a permanent injunction as well. So undue delay is not an articulated factor in the US. It's certainly not one of the enumerated four factors that are considered at the preliminary injunction or the permanent injunction stage, but it does have a significant bearing, and it usually is coupled with the irreparable injury type of discussion, although I wouldn't say necessarily that it would be inappropriate to say that it could be considered as part of the balance of the equities too. It just doesn't have a defined space where the discussion is vested, but it does come up quite often. And I would say it's probably one of the most critical unwritten portions of the rule for purposes of trying to get a preliminary injunction. So just like Mamta and Zoe and Marianne said, time is of the essence. Do it as quickly as you can within reason. And our statement over here is undue delay. That's the verbiage that we use, but we're basically saying the same thing, I think.
Right. And when you talk about irreparable injury or probably irreparable harm for other jurisdictions, you're talking mainly, I think, about a surprise for the infringer that he's going to be injuncted, which wasn't expected earlier on, because there could have been an assumption that no injunction was forthcoming, even though there was litigation pending, and the assumption might have been that there would be a remedy which was considered adequate enough, like damages or what have you. Can you comment on the possibility of damages after an injunction which later has to be lifted for whatever reason, and how that features in perhaps the tactical approach for patentees when they're enforcing their patents, and that balanced against the tools in the toolkit for the court? And with that, I'm thinking about, for instance, the obligation to put up a bond before it's possible to enforce the injunction. I know that in Germany, the courts very often, if not always, ask the patentee to put up a bond in order for, to make it easier, on the one hand, for the defendant to claim damages if, for instance, the patent is later revoked and the injunction should not have been granted, but perhaps also as a warning or sort of a hurdle for the patentee in certain circumstances to enforce an injunction if, for instance, the impact for the public, but also for the infringer, is going to be much higher. So they use almost the tool of putting up a bond as something that they can use to take into account the public interest or other interests before they grant the injunction. Is that something that the courts do as well in the United States?
Yes, under Rule 65, again, that's the sort of the place you go for this information from our civil procedure rules about injunctions. That's the main rule. So Rule 65, again, speaks to the issue of security, and Rule 65C requires that there be security in order for a preliminary injunction or temporary injunction or TRO to be entered. The amount of security, though, is totally within the discretion of the court. So a court can exercise its discretion and say, I am considering the issue of security and I'm determining that none is required. That's not common, but that is possible. But typically, courts will set a bond in an amount that the court considers proper to pay the costs and damages sustained by any party found to have been wrongfully enjoined or restrained. And interestingly, in the US, the purpose of the bond is to obviously make sure that the enjoined party, to assure the enjoined party that it may readily collect damages from the funds posted in the event that it was wrongfully enjoined, without regard to the possible insolvency of the assured, as well as to provide the plaintiff with notice of the maximum extent of its potential liability to the enjoined party. So it pretty much balances those interests economically, which I think, Koen, is what you were alluding to there. Certainly with respect to irreparable injury and that aspect, which I think we'll get to, the considerations are quite more vast.
All right, thank you. Because in our system in the Netherlands, the courts are typically reluctant to ask the patentee to post a bond, even if they grant an injunction. And you have to make a case that the company or the entity is not good for the money, is going to be unable to compensate for the damages because they are not liquid enough or something like that. And when you have a big pharma case where the multinational companies are suing one another, then that is not very likely the case. So that instrument isn't very often used in our jurisdiction, but it sounds like in the United States, the courts perceive that issue as much more of an instrument in their toolkit that they can use and actively do use it.
Absolutely, they do. And like I said, they're required to consider it and technically not issue an order without one. Of course, it's, I think, important to realize too, and I neglected to say this, that the wrongfully enjoined party is entitled to a presumption in favor of recovery on that bond. Mm-hmm. But it's not automatically entitled to the damages. So those damages have to be proven. So the defendant, the enjoined party, must actually show that he or she was harmed in order to recover on the bond, if it's ever, if the injunction's dissolved.
Thank you. Marianne, in France, is the court very active in putting up bond requirements before they grant an injunction?
Actually, that's very similar to the Netherlands. The security is not requested to be posted when injunction is granted. Maybe I would make a difference between bond and security because in some jurisdictions, like Germany or in the past in Belgium, when the patentee is not a EU citizen, they have to post a bond, which is actually just made on the basis of their nationality in the end. This is something which is often and always actually requested in Germany. This has been requested in Belgium as well. There is a decision of the Constitutional Court saying that it is not constitutional to request a bond just based on the citizenship of a party, and the law should be amended. It has not been yet. So in France, we don't have that bond, which is made on the basis of the national citizenship of the applicant. And then with respect to security, that's exactly the same as you. There is no, actually, I think that maybe lawyers should think about it more often. Maybe would have more injunctions be granted if actually the patentee in the end was as well offering to post a bond and in order to get an injunction. This is something maybe that has to be.
So what you're saying is that the court may perhaps be more likely to grant an injunction if they know that the patentee is willing to back it up by posting a bond. How about India? Is a bond very often a requirement before a PI can be enforced?
No, Koen. So we have not seen any case where there is any order which has been passed asking patentee to pay the bond. So we have no such requirement. We have not seen any such instances. Yes, there have been instances where defendant has been asked to put security in case it does not want to invite a PI order. So the defendant has come forward and court has asked the defendant to deposit an amount in the court so as to secure the damages which will be quantified at a later stage, which has to be proved. At least that amount is secured and kept in court. So that we have, but we have not come across, or there is no such provision in India where a patentee is required to file a bond for seeking PI.
All right, thank you. And in the UK, is it something the court brings up of their own motion, or is it only when the defendant requests for a bond?
Sure. So in the UK, what a patentee is required to give is a cross undertaking in damages, so an undertaking that they give to the court that in the event that the patentee is unsuccessful at trial, then they are liable for the damage that the defendant has suffered as a result of the PI. As Claudia said, it's the same in the UK. The defendant will have to prove that loss, and we have had cases in recent years where there have been damages inquiries, so trials to determine the loss and damage suffered by defendants that have been subject to PIs but have subsequently succeeded in a trial on the merits. Interestingly, just to mention, actually, Koen, in the UK, I don't know if this is true in other countries, but the cross undertaking isn't necessarily limited to the defendant. So it can be to the benefit of third parties. And the most common example of that is in pharmaceutical cases, where our National Health Service can get the benefit of the cross undertaking in damages. And you can imagine the argument that the NHS will say that it hasn't had the benefit of cheaper generic products on the market for the duration of the preliminary injunction and has suffered loss. So that's quite an interesting component of this cross undertaking to damages. It's not typical necessarily for a bond or some form of security to be given. I think in theory it could, and I've certainly had cases where final injunctions following trial have been part of that has been the patentee providing a bond. So in the event that an appeal is successful, but it's the cross undertaking in damages that is commonly required.
Thank you, Zoe. For the sake of time, I'm going to do it slightly different in the sense that I'm moving to my next slide, and also taking into account some of the questions that the listeners have put up. I'm going to ask each of you, perhaps as a final comment, to look at these other factors, and I think some of them have been mentioned briefly already. For instance, one of the questions that we received is whether or not it makes a difference if the patent is licensed or exclusively licensed. I think that goes to the first question on this slide. For instance, the situation where the patentee is a non-practicing entity, they don't have their own product on the market, and how that weighs into the balancing of the interests in granting an injunction, and whether or not perhaps damages might be also an adequate remedy. And of course, very recently, we have seen so many cases coming out in standard essential patents and FRAND questions where obviously the rights holder also doesn't have a product on the market, but where all sorts of other considerations play a role, and licensing negotiations have to be conducted or have not been conducted sufficiently, and how the courts look at those. So I'm going to just ask each and every one of you as a final round to pick out those factors on this slide that you think are the most important in your jurisdiction, and offer you an opportunity to give some concluding remarks in that sense. So I'm going to start with you, Claudia.
Well, thank you, Koen, and thanks everyone for the time today. I'll start with irreparable injury, and that will take us also into non-practicing entities, and I'll wrap it up talking about those. Next to likelihood of success on the merits in the U.S., the next most important and perhaps oftentimes the most critical in the success or failure of a preliminary injunction effort is the issue of irreparable injury. If damages are adequate to compensate, then an injunction is inappropriate. It's just that simple. And so in the U.S., for proving and establishing that there is irreparable injury, lost sales, for example, won't support such a finding. Lost sales can be fully compensated with an award of money damages. The things that really seem to move the needle over here in the few cases where preliminary injunctive relief have been granted, things that are seem to have been pivotal are a demonstration of and a quantification, evidence showing that loss of market share, price erosion, reputational injury, all of those kinds of factors drive the outcome in establishing that there has in fact been irreparable harm that can't be adequately compensated. With respect to the non-practicing entity, there is no prohibition in the United States that a non-practicing entity cannot seek an injunction, preliminary or permanent. They just don't as a rule. And the reason is because for the most part, non-practicing entities can't show irreparable injury. They are going to be compensated through monetary damages, and that's what they are doing, is trying to monetize their patent through a litigation process. So I will conclude with that and thank everyone for their time and interest today.
Thank you, Claudia. Just as a final question to you, if I may, I don't think you've spent much time talking about the public interest. Is it really an assessing of the interests of the parties in the case, or do any public interest defenses play a role at all?
Well, it's certainly the public interest. There's a strong public interest in promoting inventions through proper protection of patent holders' rights, and you know, if an injunction does not serve the public interest, then obviously it's not going to be looked upon favorably. Typically, those factors, though, don't get that much consideration. The first two factors I talked about drive most of the decisions, and these are tag-alongs, but they are considered in every case. And there are circumstances where the actual public interest is at issue as opposed to just the issue of the parties. But the parties' interests are typically thought to be representative of the public interest. So, for example, patent holders' rights protection would be a public interest, but represented by the particular party before the court.
Right, and of the alleged infringer or the defendant, that would be the public interest in, you know, more competition, lower prices, things like that.
Absolutely,
Yeah.
absolutely.
All right, thank you. Then I turn to you, Mamta, for India. Any of those factors on the slide appeal to you particularly?
Yeah, thank you, Koen. So as a final remark, I would like to say in India, which is starkly different from US, is if you are not practicing the patent, you are not working the patent, you will not be entitled for a preliminary injunction, though you will be able to file a suit and your suit will be maintainable. So that's a very, very, I would say, a different position. So far as damages are concerned, adequacy of damages may arise in some cases, and it depends upon industry to industry. As you have already mentioned, that standard essential patents are the cases where it is always argued that if you can be compensated, it's after all a matter of license or royalty fee to be determined. So therefore, YPI, the damages can be compensated, and therefore that is a very relevant consideration. So far as public interest is concerned, we have in our provision have certain statutory provisions which has given powers to the government, wherein a compulsory licensing may be sought if it is a case of a public interest. Even if it is a case of national emergency under section 92 of the act, the government can use the patent. So far as in the PI perspective is concerned, public interest by itself may not be a determinative factor, and I think Claudia also said so. It will be one of the limb which is attached to balance of convenience. So at a PI stage, you are still required to first move to the prima facie stage, and that's the most pivotal point. When you move from there to balance of convenience, and if there is a public interest argument is raised, public interest will be one of the limb of balance of convenience, and then still the parties will be independently impressing upon the court that which party is having the irreparable injury. So it will again, as you had said, the public interest is also attached with the patentee's right in patent, because the invention also is in public interest. So all these aspects are weighed during the time of adjudicating, either at a PI stage or a final stage.
Thank you very much. How about you, Marianne? Any factors on the slide that you think the French courts find particularly important when they're assessing pretrial injunctions? And can you also comment on the public interest point? Yes.
So I would say that, first of all, one of the requirements which are taken into account by the French court is whether the product is on the market or not. And I would say that for imminent threat, the threshold actually to prove that there is a real imminent threat is very high. So it's very difficult actually to obtain an injunction when you have an imminent threat. Then with respect to NPE, or whether the product is on the market, the patented product is on the market or not, actually exploitation of the patent is not a requirement under French law, which actually was the case in the past many years ago, I would say 30 years ago. But in the end, it is taken into consideration because when the court will decide whether actually the damages would be more adequate than actually putting an injunction, then they will take into account whether or not there is a product on the market or not. Because if you have a product on the market, actually, then obviously injunction can be justified. If you don't have a product on the market, you can be compensated in money. So actually, that's really I would say the infringer, which has to prove that the product is not on the market, because you have not to prove that your product is on the market. And I remember many years ago, I obtained an injunction against a company when actually my client had no product on the market. But it was not said in the case at all. And in the end, I obtained an injunction where I had no product on the market. So I would say that here, really what matters is the adequacy of damages as a remedy can be a bar from getting an injunction. With respect to public interest, I would say that actually the court will not really take into account the public interest. They will just look what would be the impact of their decision, and more often they will take this public interest when the patent is about to expire. And then more recently, I would say in the front case, that is in the IPCOM case at the beginning of 2020, where in the end, the injunction was not granted because it was decided that the impact on the market would be too high, too high and too strong, and because actually the patent was just about to expire. So really, that's why in the end, it's not really public interest, but really that's the impact of the decision that is going to be taken into account. So again, we're back to proportionality of the measures.
All right, thank you. And then last but not least, certainly Zoe, for the UK.
Sure, thanks, Koen. So just a few words. I think really picking up actually on what Claudia said, I think the thing that really leaps out at me from this slide is the third bullet, the adequacy of damages as a remedy. And this is really key in the court's assessment when it comes to a preliminary injunction. Will the patentee be adequately compensated in damages pending trial? And picking up on two other things on the slide. So first off, looking at it in the context of the life sciences, the pharma field, and one of the bullet points there is clearing the way. So typically in the UK, on this adequacy of damages as a remedy, the court has taken, there's been evidence for the court to take the view that a pharmaceutical company with a patentee would suffer irreparable harm because of a dramatic downward price spiral, potentially with multiple generics coming on the market and the patentee being unable to recover its price if it's successful at trial. And that has sort of been enough for it to establish irrecoverable loss. And then when the court has come to look at the balance of convenience, accepting that the defendant would suffer irreparable harm if injuncted, this sort of doctrine of clearing the way has very much come into play, where the court has taken the view that generic companies should be aware of the patent landscape, and if they choose not to take action to get declarations of non-infringement or findings of invalidity, then they take the consequences when it comes to a preliminary injunction, and that plays into the balance of convenience. But as I mentioned, that case, the Neurim and Mylan case earlier, that's actually an example of a pharma and generic case where a PI wasn't granted, but that was because that the patentee failed to establish that damages wouldn't be an adequate remedy, and it was specific to its facts, but it shows the importance of that as a factor. It also plays into this idea of the non-practicing entity, and I think this is an example where it shows actually the difference, certainly in the UK, between a permanent injunction and a preliminary injunction. I think typically it's going to be very difficult for someone that's not practicing the patent and is probably licensing the patents, then damages are going to, in all likelihood, be adequate. But when the court then comes to look at a permanent injunction, obviously we saw this very starkly in the Supreme Court decision in the Unwired Planet case, which concerned non-practicing entities. The court took the view that an injunction was appropriate, albeit an injunction that would only bite if the defendant didn't take the license that the court had settled as being the appropriate FRAND license in the circumstances. And I mean, Marianne mentioned where there was the preliminary injunction case in the IPCOM proceedings, and we had a parallel preliminary injunction case there in the UK between IPCOM and Xiaomi. Very unusual in the MPE standard essential patent field. But there the argument was rather different, where the IPCOM tried to argue that their irreparable harm was actually their loss of opportunity in being able to ask the UK court for to settle a FRAND license, because A, the patent was about to expire, so a permanent injunction would be off the table by the time of trial, and Xiaomi was not prepared to undertake to take whatever license the court said was FRAND as a way of avoiding the preliminary injunction. So it was quite specific on its facts, quite an interesting case. It's worth reading, IPCOM and Xiaomi. But I think that shows the difficulty for MPEs when it comes to preliminary injunctions.
Thank you very much, Toby. And I'd like to thank all the panelists for their contributions. And I think for me, the takeaway message of today is that, yes, there are differences between all the jurisdictions, but there's also a huge commonality, and that is certainly in the context of pretrial injunctions, preliminary injunctions. Almost everything goes, and it's almost like a lawyer's paradise where you can be creative, but because there are no hard and fast rules that the courts apply, and all the circumstances of the case are to be taken into account. And that's, to me, what makes this area of law so very interesting. So again, thank you all very much for your contribution. Thank you for everybody patient enough to listen to us for a little more than an hour and a half. For those of you who have asked questions that haven't been answered, I do apologize, but I hope you found it all interesting. Thank you very much.
Thank you, Koen. Bye.
Thank you. Bye.
Thank you. Bye.
Bye-bye.
Bye-bye. Thank you.